Filing probate, dealing with the court system can be an overwhelming process, especially if you're a first-time executor. Joining me today is Micah Hall with the Hall Law Firm to discuss a little bit about executor mistakes, executor surprises, and what you can expect when you're dealing with the court system during the probate process. Micah, thank you so much for joining me today. I greatly appreciate it.
My pleasure. Thanks for having me.
For someone that's watching that's not familiar with you or your firm, can you tell us a little bit about the type of law that you practice?
Absolutely. I practice estate administration, or what most people call probate, estate planning. Those are my two areas. They're completely different, but you can see where they intersect in some places. For example, probate happens usually because someone doesn't have a proper estate plan.
Absolutely. Now, I noticed that you've been practicing law for a long time. What makes you so passionate about helping families through estate planning and probate type needs?
I think it comes from number one, being a first generation professional, even a lawyer, and having that mindset to leave a legacy for the next generation. And I think it's important for families to do that, especially in my case, families of color. When I first started doing estate planning and probate work, I realized that it was one of the areas that wasn't as readily or widely known or understood. I thought it was a great way to do my little part of helping families leave a legacy, not just legacy of money, but legacy of traditions, legacy of family values. Just a family legacy generally.
What do you think stops people from trying to leave that legacy or prevents them from doing more estate planning?
I think it's really people are not aware of it. And if they are aware of it, it's overwhelming because they don't know much about it. They don't
Right.
understand it. Estate planning used to be thought of as rich man's tools.
Mhm.
And I think that people with lesser means just didn't think that it was something that could assist them. It wasn't something that was reachable. Now, with more mainstream information being out there, I think people are realizing not only that, but as we gain more sets in life, right? You start realizing you work hard to get what you have. And if you have loved ones that you want to leave it to, you want to make sure that they're protected, you want to make sure that they're valued properly, but you may not know how to do that. I think that's really the reason people are just not aware of what estate planning is or can do for them. If they are aware of it, it may seem daunting or overwhelming.
Right. Sounds like it can be hard for a family to really take advantage of estate planning or to get motivated to plan for their future.
I think getting motivated is definitely the difficult thing. It's like estate planning is not one of those things that people automatically feel like they need, right?
Right.
Of course, to me, it's essential, but it's essential when it becomes a problem. And
Right.
that's when people realize, oh, I wish I would have had that, or I need to get it in place right now. Um, but is essential just to be prepared and be responsible
Right.
as a person who has whatever they have. And if you wanted to leave it, leave some type of legacy to your loved ones.
So how can proper estate planning help prevent or make the probate process a little bit easier?
Well, a proper estate plan that's executed properly can actually avoid probate in most cases. That's really the goal for most people. I know that's usually what my clients want. When they come to me, their goal is to avoid probate if they can. Because probate is a court process that is lengthy, can be is expensive, it's time consuming, and you have to deal with that process while you're grieving a loved one, right? That's passed
Right.
away. And so to avoid that process, it could be enormous for people. So estate planning, if it's done properly and the documents are in place the way that they should be based on the family dynamics, then it can absolutely avoid that process. Make sure that you have beneficiaries, make sure that you have joint owners if you need to, make sure that you have all the documents in place so that assets properly pass down to living persons without having to go to probate. So a good proper estate plan can avoid probate altogether.
So it sounds like it's fairly easy to avoid probate if you really take the time to think about it, I guess.
I would say that's true. And like me doing this, of course, it does seem easy, but I also understand the challenges that people face. It's a lot of paperwork to gather together with all of your assets and figuring out what to do. That's a process in itself. Not to mention that With estate planning, people start thinking about their own demise, and that gets overwhelming and it stops them in their track. And it's hard to move on for that for some people. They don't want to think about what happens when I'm gone. But the reality is, we have to think about that. We think about that when we get life insurance policies. We
Right.
think about that when we get a new job and we have to fill out who the beneficiary is going to be on our pensions or 401ks or IRAs. So estate planning is really just an extension of that. It's just taking it a step further to say, okay, maybe you've done these things with retirement, your pension, your life insurance, but what about your other assets?
Right.
That's what it essentially is.
Well, what other assets can you help protect that will avoid the probate process?
Real estate is the number one. People
Mhm.
who own real estate, whether it's their residential property, whether it's vacation property, whether it's property that's passed down from generation, real estate is number one. Any asset that would have a death benefit, is something that can be protected. And I'm not talking about just accounts, right? Even intellectual property,
Oh,
people
really?
who have
Okay.
royalties, people who've written books, right? Personal property, jewelry,
Right.
guns, any type of property you can think of that a person can own, whether it's tangible or intangible, can be protected. Now we live in an age where you have cryptocurrency. You
Right.
have some people have websites or things like that, intangible, but they're valuable. Those
Right.
are things that can also be protected.
Okay. And how do they protect those things? How simple is it to protect them?
So, and it depends on what type of vehicle you have for an estate planning. For example, trusts are one of those that are very versatile. So you can, with a trust can own any type of asset, whether it's real
Oh,
property
really?
or personal property. So a lot of people will assign their intangibles or tangible that have account numbers, real estate. They will transfer those to a trust so that it's protected. And the great thing about a trust is you have your built-in beneficiaries right there. So
Right.
whatever's in the trust, guess what?
That's where they
Bypasses
go.
probate.
So can cryptocurrency be put into a trust?
Absolutely.
Oh, I didn't know that. What
Yeah.
about a book? If I wrote a book or intellectual property, can that be put into a trust?
So the rights and the royalties that you get from that,
Really?
absolutely, those can be assigned.
Okay.
Income can be assigned to it. You see that all the time. People who, musicians, authors.
I wasn't aware of that. I knew real estate could. I deal with that all the time, right? But I
Yeah.
didn't know about, you're right, cryptocurrency is a big thing now and starting to become bigger. It's
Yeah.
great to protect it. Well, how often do people come into your office or you meet with people and they've done some of the stuff right, but not quite all of it? How often does that happen?
So I think, especially with the internet and TikTok and Facebook, there's attorneys and there's financial advisors all around that talk about estate planning. So I think people are more educated than they have been in the past.
Right?
They're not always educated correctly, but they at least are aware of what estate planning is, what the documents involved. They at least have some limited knowledge, which makes it easier for me because now I can go in and apply they've been thinking about with their actual assets. And it's not this, outside theoretical thing. It's you're able to put it in real practice, especially when they come in having some knowledge of
Right.
what it is.
So it sounds like you have dealt with people that have gone online, tried to do something with it, create their own will or that thing, or some documents.
You do have some people, sometimes they realize that they're in over their head and it's something that they would rather have an attorney complete.
Mhm.
Um, and sometimes they want you to review whatever they've done on their own. Now, I myself, for ethical reasons, I don't review documents that I don't draft.
Right?
But one thing that I caution clients about or potential clients when they come see me is it's fine to do it on your own if you want to do it on your own. You just want to make sure it complies with state statutes because with the state that you live
Mm,
in, you have all these general forms out there that are
yeah.
anyone in any state can pick up, and most of them are not paying attention as to whether that requirement applies to their state. And then they find out when it's a little too late.
Right. Well, how often do you see a will or something or documents that someone's done that don't meet state standards or state statutes, I should say?
It happens more often than you think.
Because I imagine most people don't realize there are state statutes that
Yeah.
govern these things, and they don't even think about that. Well, how often do you have people come into your office that say, "Hey, look, my loved one just passed away, and we need to now start the probate process"?
That happens. I get that call pretty much every day. And my first question is there some type of estate plan in place? Most of the time, 90% of the time, that answer is no.
Wow.
10% of the time, I get There's a will, sometimes maybe a trust. But most of the time, people don't have any type of estate plan that will either avoid probate or limit the probate process.
In that case where there's no estate planning documents and it has to go through probate, what can an executor expect this phase, or what are they looking at when they start dealing with the court system and probate?
Well, the first thing that they need to be aware of is that it's a process. It is a process, and there are multiple steps to that process. The other thing that they need to be aware of is that it's a public process. It is public in that it's the court is now online where anyone can access it. So the documents are viewable by
Oh,
pretty
wow.
much anyone. It has to be published in legal newspapers. So it is a very public process. So they need to be aware of that. They also need to be aware there's costs associated with probate. Not cheap. There's costs that for attorneys, if you decide to retain one, there are bond costs, there are costs for publication, there are court costs. And a lot of this is based on the value of the estate. So the more the estate has, the higher the cost goes. And the average is about 5 to 7%
Wow.
of what the value is. That's how much it's going to cost to go through probate with all of those fees. You have real estate fees, right? If you need to sell a home, transfer fees. What happens if there's property that's in a different state that needs to be transferred back, or in this state that needs to be transferred somewhere else? There's fees associated with all of that.
Well, I'm sure that the county and state governments always want to try to get their piece, right?
Yeah,
Yeah.
absolutely.
Yeah, gotta pay them. So it sounds like if somebody had taken the time and paid you to do a proper estate plan, it would have saved them a lot of money on the back end.
That is a true statement. And that's another reason I think people shy away from estate planning, because it may feel expensive up front, but it's not nearly as expensive as probate on the back end. Not to mention that estate planning is not just for after you die, right? Estate planning could be planning for what happens if you have an incapacitation, whether it's
Right.
short term, whether it's long term. You need someone to step in and take care of bills, handle your business, or help you manage your health care if you're not able to do it yourself. So it's estate planning is not just death. It's also what happens if I'm living and I need some type of assistance and haven't already put a plan in place for who's going to help me do that.
Right.
That's what it is.
How often do you have families come to you that say, "Hey, mom's got dementia now, and we want to do some estate planning"? How do you handle situations like that?
Happens pretty often. And that goes to back to what I was saying earlier. People don't think estate planning is essential until it becomes essential. And when mom has dementia, and there's a degree of dementia, early onset on to more egregious form of it. Us attorneys are not medical professionals. We have no idea at what stage it's in.
Right.
Only the doctor really knows, right? Their physician. But what we do know is that there's a thin line between mom being competent and not competent.
Really?
And so at some point, and the question is, where is that line?
Right.
And so mom having dementia now, it creates concern for an attorney to draft these documents today because she may not be competent enough to sign those documents.
Right.
So if that becomes the case, your only option is guardianship. And
Oh, wow.
wow, that's part of the probate process, right? Now you're thinking, if I would have came in a month earlier, a year earlier, and got this estate plan in place, that guardianship wouldn't have been necessary.
Wow. Well, how much? I know every county is a little different, right? In Mecklenburg County, there's a lot of probate being filed compared to maybe some county way out west that's really small, right? So I know there's a big difference, but here in the Mecklenburg County area, how long does probate process typically last?
It depends, of course, because every probate is different. But on average, probate's going to take about a year.
Oh,
And
wow.
possibly a little over a year. Now, of course, that's on average, and it depends on what assets there are. Is there a will? Who are the beneficiaries? Their parentage issues. Are there beneficiaries that cannot be located? So there's all these factors that go into it. But generally, if everything goes well, you're looking at estate lasting approximately a year, maybe a little longer with
So
court processing times.
So compare that to if someone had done a proper estate plan. How much time would it take if they a proper estate plan in place compared to the probate process?
That process can be done in 6 to 8 weeks.
Wow, that sounds so simple to do. Then that's a lot more efficient.
It is not only a lot more efficient, but Think about it this way. You have a plan in place and you have a good attorney working on it. They're going to make sure that anything that you acquire later is going to be encompassed in your plan, right?
Right.
Of course, we can't account for life changes and things like that because
Hmm.
life changes, but we create it in a way that, except for those major life changes, this document will grow with you and go with you. So you pay this fee one time, you have a document that you're able to maintain, for years.
Right.
And so it's something that is an upfront cost, but boy, isn't it saving you on the back end?
Absolutely. It sounds like it does. It's really good. Let's go back to a little bit about people that are going through the probate process and really haven't planned that much. It sounds like they're really surprised when they start seeing all how expensive it can be and all the different hoops they have to jump through
Yeah,
because of the court.
absolutely. When I counsel clients, the first thing that we do is go through expectations about the cost, about the time, about the fact that this is a process. And I also have to remember and be empathetic to the fact that they're grieving while they're going through this process, right?
Right.
They're going through it because a loved one has passed away. And when you think about those emotional factors as well, that also factors into the timing. Sometimes it
Right.
takes people a while to go through things emotionally, and then it takes them a while to get through things physically, to get the paperwork that I need, right? To file that with the court. So those things come into play. I make sure that my clients know exactly who the heirs are, if they can, and their contact information.
Yeah.
What documents did they have? Everything about probate is what assets did this person have before they passed away? You need to
Right.
know what those assets are. They need to have some type of value. You have to have some idea of where they are. They need to be secure. So there's a lot that goes into it.
So it sounds like the executor then has a lot of work to do if it does go through the probate process, trying to find all that information.
So they have a lot of work to do before you even complete an application. And then
Really?
once they're appointed as the executor or personal representative or administrator, whatever their
Yeah,
role
whatever.
is,
Yeah.
they have even more work to do.
Really?
Because once you get appointed, then now it's time to actually account to the court what the actual values are. Because you got to think a lot of us are private, right? We're
Yeah.
private
Yeah.
people. We don't want everybody in our business. We don't want everybody to know that we have a bank account here, a bank account there.
Right.
So when someone passes away and the executor comes into play, they may not know what all of the assets are at that time.
Really?
They may know
Yeah.
some. Sometimes I
Yeah.
have clients that know nothing. And you, until you get appointed by a court, won't have any authority to find out what a person actually owns. So sometimes it's trying to gather information through sources like mail, or do family and friends have any information? But until
Right.
you get appointed, you won't have any court authority to actually go to those banks, get statements, to inquire their job, what their pension amount was. That court document is what allows an executor to be able to act.
And what's the name of that document you were talking about that gives them the authority to do that?
So it's called letters. If you are the executor that's named in a will, and that will is considered valid, then it's letters of testamentary. If there is no will, then you're getting letters of administration.
Okay. But it sounds like they do exactly the same thing. They allow
They
you to.
do. They
Okay.
definitely do. Same functions, same responsibilities, same requirements.
Right. And how surprised are your executors when they realize they can't do anything until they get these letters, this
Very
authority?
surprised.
Really?
Very, especially if they have a will, because they feel like this will says that I'm the person. And my explanation is the will nominates you, the court appoints you. And until the
Ah,
court appoints you, you don't have that real authority, right?
really?
Yeah.
Absolutely. So a few minutes ago, you mentioned that you sat down with your clients and you talked about the expectations. Based upon your experience, what when comes to your office the first time, what are their expectations versus what you talk about? Or how do you change their expectations?
And it depends.
Yeah.
Sometimes people have gone through this or heard about it through friends or family who have gone through the process. So they have some idea. They just may not have been the ones on the front lines doing it. And then you have people on the other spectrum that have never even heard of probate, and somebody passed away and they tried to handle it and was told you have to go through probate. And now they're trying to even understand what is probate. So I
Right.
have clients on both end of the spectrum. And first I just try to gather, what do they know? And then I just dispel it.
So it sounds like a
Yeah.
lot of your job is just dispelling myths and rumors, I guess,
Yeah,
right?
it is a lot. It is a lot. But
Well,
I do have some clients who are more astute because they've been through it
right.
before for another family member. So they're aware. But most people have very limited knowledge.
Based upon your experience, what's the biggest myth that you come across when you're first talking to a new executor, first time
The,
executor?
well, the biggest myth that I've ever heard is, why do I have to go through probate when there's a will? That's the biggest one.
Okay.
Most people, I won't say most, I will say some people have this misconception a will avoids probate when that's really the opposite. The purpose of a will is to go to probate. A will is your declaration to the probate court about this is what I want to happen with my stuff when I die, right?
Right.
And so that's the biggest misconception. Another misconception is that they can just do whatever they want with the assets. They can spend money here or do something there. And so we have a really in-depth conversation about fiduciary duties because that is what an executor or an administrator is. They're a fiduciary
Right.
and they're responsible to make sure that the estate is intact because there's potential creditors, which is another misconception. But there's potential creditors out there. There's all these fees that have to be paid, and then you got to think that there's distributions that have to happen. So you have to
Right.
make sure that all these assets are properly there, so that they go to who they need to go to before the estate can end.
Right. It sounds like the court is really picky about this paperwork and accounting for all this information and all these values and the whole process.
Absolutely. And like I said before, there's a process. And within probate, it's hard to get to the next step if you can't complete the first one. So people run into issues if they don't know what they're doing, or if they're not providing the court what they need, what the court requires, and what's statutorily required to get through the process. And if an executor can't do that, it can end up being them being removed from their position. And if there ends up being some misdeeds that happen, there can also be some really nasty consequences, financial and criminal
Right.
consequences.
It sounds like it costs them a lot of time too.
Oh, there's a lot of time because when what the administrator is doing, the attorney is like doing all the legal work, right?
Right.
But there has to be boots on the ground to go to the bank to do this or go get a copy of this or and so that administrator is doing the footwork.
Right.
So it is a lot of work for them. And it's a lot of footwork and boots on the ground to be able to go and take care of these matters and gather the information that I need as an attorney to prepare the documents.
Right. How often do your executors or your clients expect you to do all that boot work or groundwork?
Never, because
Never.
I set that expectation
Okay.
at the beginning. That is their job.
Right.
My job is to protect them legally and make sure that they get through the process in a clean way. But them as administrator, that's their job. Now, if they need assistance, like they're having an issue at the bank and a bank is not honoring something, of course, I will always step in and assist. But their job is to collect the information, gather the documents. I also assist with helping to value the assets because I know that's not easy for most clients,
Right.
right? But I have a client now who has coin collection and help them find a place to take it to get valued. But I'm personally not taking it to the evaluator. They have to
Right.
do it. But I was there to assist to say this place looks reputable, or heard from another colleague that this place is reputable. Let's see
Right.
what they're going to give a value for. They're doing the actual footwork.
But it sounds like you get really involved though in the
Oh,
process.
I absolutely do because I want to make sure that my client is successful getting through that process as well. They shouldn't just be there out there on an island trying to figure it out themselves.
Absolutely. Hey, can we pause here just for a second? It seems to have frozen for a second. There you go. We're good. You froze up there for a second. Sorry about that. Okay, great. So it sounds like all this could have been avoided if they'd done proper estate planning to start with, right?
You have some people that are just adverse to estate planning for whatever reason. I know some of the older generation, they were used to putting money under mattress,
Yeah.
hiding it somewhere in, a crevice in the wall or
Oh
whatever.
yeah.
And they just don't see the need for estate planning. That's been my sense. Not all of them, but I've gotten that sense through the years. I think that baby boomers, the generation is more inclined do more estate planning. I think they see the value in it. Most of them are nearing retirement or already
Right.
in retirement. And so they see the value in it. I'm also seeing that the younger generation is getting more astute to estate planning and wanting to have assets protected younger and younger.
And when you say the younger generation, are we talking Gen X? Are we talking millennials or whatever comes after millennials? What does younger generation mean?
I don't even know what generation. I will say that I think my youngest client right now is a college graduate or
Oh,
recent
wow.
college grad.
That's good. I never would have thought, coming out of college, estate planning was the last thing on my mind.
Same.
Yeah. I just know that you have to go through probate with my parents. It really made me start thinking about estate planning and the hassle of it. And like you said, it was just a long, drawn out process. And just wanted to spend the money up front to get it knocked out to
Yeah,
start with,
yeah.
right? So for a first time new executor, somebody that's watching that's just a brand new executor, never done this before, what's one piece of advice that you would give them before starting the probate process or before giving you a call?
Probably the biggest piece of advice would be have a good idea, if you can, what the assets are and what the value is. Probate is all about values and what those assets value. Even though we're talking about probate generally, there are different types of probate processes.
Mhm.
And so, the more information you can have about the assets, the value of them, as well as who the heirs are, that helps the attorney know exactly which probate process needs to be done.
Okay. That's good. I didn't realize it could be that complicated. So
Yeah.
that's pretty unique. So what's one thing we should have covered but didn't really talk about?
Oh, I feel like we covered a lot, but
We
let's see.
did.
Whenever there are minor children who are beneficiaries going through probate, one thing that executors and everyone really needs to know is that minors, children under 18, they can't just hold money, right?
Okay.
So whenever you have minors who are going to receive distributions from an estate, there may be another mini estate or guardianship of the estate set up for the minor child so that money could be held there for them. So you may have a probate process within a probate process because you have a
Really?
minor child.
Okay. So who gets the privilege of setting up the guardianship or appointing being the guardian of that minor child?
It's usually that child's guardian, natural guardian, meaning their mother or father, unless it's the mother or father that passed away.
Right.
And then it's usually either the other parent or sometimes grandparents will step in, aunts and uncles will step in.
And how involved does the court get in approving or disapproving the guardian?
Very involved. They have to approve that the whoever is applying to be the guardian is suitable to do it. And then when it comes to the funds of the child that are going to be held, there is an initial inventory of what that looks like. And then who's ever going to be that guardian for that child's estate, they have to do an annual accounting to the court
Oh, wow.
of everything that has gone out, everything that has come in, and they can't do it really anything without court approval. So there's court is extremely involved in those cases.
Wow. So if a child is 12 years old or whatever, 8 years old, it can last until they're 18. Is that
Yes,
right? Every year would have to file that form or file with the court of that county. Well,
that's correct.
that's got to take a lot of time then, or it's got to be quite cumbersome.
I'm sure it is.
Yeah.
Absolutely. I have one now where a 1-year-old is in that state. So we're looking
Wow.
at 18, 17 years of this child's funds being in a guardianship.
Now, can that money be invested? Can it draw interest or be like a mutual fund or something? Like a
Absolutely.
group? Okay.
Yeah,
Well,
it
that's
can.
good then. So
And it
then
should.
it should be, yeah. That's good. Then what happens when the child turns 18? What happens to the money then?
So this goes back to the reason why estate planning needs to be done in the first place, because in that situation where it's a court guardianship, when that child turns 18, that child gets that money in one lump sum.
No way.
Absolutely.
So you can have an 18-year-old kid get 50, $60,000 or whatever it could be in
And
one
in
lump
some
sum.
cases, $1 million. Yep,
Wow. God.
absolutely.
Okay.
Whereas the estate plan parent would have done an estate plan basically stating any assets that this child received goes into a trust, for example.
Yeah.
They could put terms in the trust that says they don't get it at 18.
Right.
They can get a portion at 25, maybe a portion at 27,
Yeah.
and build on it from there.
Right. I know there's some responsible 18-year-olds out there that are probably more responsible than I am, right? I get that. But most of the ones that I've met, aren't responsible at 18, and I'm sure they could blow through a lot of cash real fast.
Oh, they will be with you.
So that sounds like there's another good reason to do estate planning then, to make sure your kid prepares for the future, a retirement in the future, and is set for life.
Absolutely. And even with adult children, sometimes you have adult children that are not great money managers,
Yeah.
right? Or what if they have addictions, or what if they have gambling problems? And it's like you still want to care for your child, but you want to care for them in a way that's responsible.
Right.
And that's another way that parents can ensure that they're still leaving their legacy, but they leave it in a way that's responsible.
That's very interesting. But if someone wants to get in contact with you, maybe they need to start probate, or maybe they want to talk about estate planning, how's the best way for them to reach out to you?
Absolutely. So the best way, of course, is either call my office. That number is 704-771-0326. Or you can always reach me at my website, which is mhallfirm.com. And I have a lot of information on our website about estate planning and probate. I have blogs that I do every month, and they're on the
Awesome.
website. So there's a bunch of information that's there. And then I'm also on social media, the Hall Law Firm. So you can find me there as well.
Awesome. Well, great. Micah, thank you so much for taking the time today. I know you're really busy and take a little bit of time out of your schedule to do this. I greatly appreciate it. And I'm sure someone watching will find some great nuggets to learn from.
Absolutely, my pleasure. Thank you
Great.
so much for having me.
Great. Micah, you have a nice day. We'll talk to you soon.
All right, you do the same.
All right. Bye-bye.
Bye.